Recording has started.
Their response memo and some.
Good evening. I'd like to call to order the January 28th, 2014 three-member administrative panel hearing of the Board of Building Regulations and Animals Appeals. We can take roll call, please.
Okay. Mr. Feller?
Here.
Mr. Ferdine?
Here.
Mr. Steele?
Here.
And for staff, Ms. Walsh? Here. Mr. Knopfinger?
Here.
And Mr. Sam Severin from legal?
Here.
And, excuse me, and appellant is Mr. Bill Taylor?
Correct. Here.
And Rebecca Wint?
Yes, correct, here.
And in the audience, we have Mr. Scott Boney.
Thank you. First item on the agenda following roll call is new business, and it is case BC1-01-2014, Colony Builders, an appeal of decision regarding 2310-103.4.1.A.2. At least two members of the panel will be actively engaged in disciplines trades that are relevant. So before we get into the specifics of this appeal, I don't know if everyone has received it, but part of our packet was 23, or a segment of 2310-016 order of business, appeals from action of administrative officials. And these outline the specifics of how we hear appeals and decisions of the administrative officials. So the introduction of the case, as far as I'm concerned, is the reading of the appeal itself, and we will at this point administer oath. So everyone that is going to speak relative to this issue, if I could get you to affirm under penalty of perjury that the testimony you're about to give in this matter before us is the truth.
I do.
I do. Is anyone else speaking?
I do. I may call Mr. Boney as a witness, so he should also affirm.
I do. I do.
I do, generally as an attorney, I don't consider it testimony, but
At this point, we will start with the staff outlining the case under consideration, and then we will move to the appellant and any of their witnesses giving their presentation. And then following that, the staff and any witnesses shall make their presentation. Both the appellant and the administrative staff, in addition to the board, may ask questions through the presiding officer of the opposite party after each presentation has been completed. The appellant shall then have the right of rebuttal, and any party may be represented by legal counsel before the board. Formal rules of evidence applicable to action at law do not apply to hearings before the board. The only requirement is that the evidence be relevant to the matter before the board. The burden of proof rests with the appellant, who must convince the board by a preponderance of the evidence that the appeal should be granted. The findings of the board shall be specific findings of fact and conclusions of law. The affirmative vote of a majority of the fully constituted panel, I assume is correct in this instance, is necessary to grant an appeal in whole or in part. And then the chairman shall advise the appellant of the board's decision, and this will be the panel's decision, and advise him of the appeal provisions. So following this outline, I'd like to first start with staff outlining the case under consideration.
Okay. Thank you. Thank you, Mr. Steele. Okay, on December 9th, 2013, Colony Builders brought a case forward to an appeal panel of the building board. The matter being appealed at that time concerned the ability of an applicant to turn in parts of an application at separate times rather than turning in a complete application. The secretary to the building board, i.e. the building official, and the chair of the board assigned 3 available members to the panel. Colony Builders objected to the makeup of the panel and requested that at least 2 of the 3 members be engaged in residential construction. The building official, myself, responded to Colony Builders that the appeal concerned the terms and conditions of submitting a permit, and that the panel members selected were engaged in professions relevant to that process. And the letter of December 5th is attached. It was also included in the appeal itself. Colony Builders is now appealing the building official's interpretation, as presented in the December 5th letter, that the panel members for the December 9th appeal were engaged in professions relevant to that appeal. It's important to note Colony Builders is not appealing the subsequent decision made by that panel on the evening of December 9th. So this is basically, essentially an appeal of the letter, of the conclusions reached in the letter of December 5th. At this time, staff offers that tonight's panel can and should decline to hear this appeal. There's nothing in the code that gives this panel power to direct the building official and the chair of the boards to assignment of board members to a panel. Mr. Sever can answer any questions you may have as you deliberate on whether or not you should exercise the option to decline to hear the case, as described in the memorandum of appellee that was distributed yesterday. And I could ask questions of Mr. Sever at this time on that option.
Was something distributed yesterday?
Yes, it was, and did you?
I sent you an email this morning because you were left off Ms. Wink's reply, and you should have copies of everything there.
In this packet?
Uh-huh.
Thank you. So, if I might, Ms. Walsh, your suggestion at this time that it might be, if the interest to move away from the list of process and actually get a bit of background from legal as to, if we were to choose not to hear the appeal, what the ramifications or options are.
Thank you. Yeah, the thing was titled Memorandum of Appellee, and basically what I wanted to do with it was set the stage, kind of just to put you on notice that we will be making the argument that it's appropriate for the board to actually decline to hear the substance of the appeal. Basic ground for that is mootness, that it's no longer proper, and that the board can't really grant the remedy of making an order that the building official follow the law correctly in the future. The reason it's moot primarily, when we were here on December 9th for the actual hearing, was about the denial of the packet not being complete. And at the time of the December 9th hearing, one of the things that was deliberated about to some extent was, since Colony had actually already gotten the permit by the December 9th hearing, the December 9th hearing itself was to some degree moot. It just basically didn't matter anymore. Now we're going back to a hearing about the makeup of the board on December 9th that decided that moot issue. The issue's already been decided. And Colony is not asking to reverse or change the decision made, which was made against it on December 9th. It's just saying that an administrative step prior to the December 9th hearing about the makeup of the board was done incorrectly. The thing that is, I guess it's been kind of frustrating for me to try to express, and that's why I try to do it in writing, is that the issue's over. Nobody's asking to revisit the actual decision of the December 9th hearing. It's just the board that rendered that decision. So there's nothing to, there's no real relief to grant. So I kind of call it, I don't remember what's written down here, moot upon moot, really. And another aspect of that is, if there was a complaint about the composition of the board and or the decision that they made, that could have been appealed to the full board, who could have then taken the whole thing, which still was a live issue at that point in time. I mean, then they could have considered the December 9th hearing, and then the question of what happened on December 5th would no longer be just a purely academic sort of issue. And again, their calling is not asking to change the outcome, and that's why in my brief, I tried to make it as short and try to get away from citing a lot of law and making it a legal brief, but I was trying to come up with examples of a situation where a court would, if, for example, you had parties from Fairbanks and Anchorage, and the decision was made to have the trial in Anchorage, one of the parties felt that it should have been in Fairbanks, it would be a very rare exception where a court would say, yeah, we'll hear that decision, we'll make an appeal, we'll allow an appeal to go forward on the decision of where to have it, but you want to just go ahead and keep the verdict as is. If somebody asks, well, we're not upset about what actually happened, we just don't like the decision to do it. Generally, there are some rare exceptions where the court would do that, but otherwise the court is concerned about things that are actual live controversies and just won't do that. And is this a court or not? The theory is much the same, and I don't think there's any reason the board couldn't decline to hear this on that mootness ground, that there's nothing left to actually appeal. And the other problem, the thing that I raised in the memorandum was, I'm not sure what the remedy would be. I mean, of the powers the building board has, the only one that I see that's like an advisory, like building director, building official, you must do this in the future. Anything like that, other than hearing finite, independent, individual appeals of issues that actually are still live, there's a certain future ability, which is to offer comment or recommendation concerning amendments to building code and regulations in Title 23. But that's something short of a mandate or direction to the building official to follow the code. I just don't think that there's any sort of remedy that the board can actually do here. And as far as just if you wanted to do that, I mean, can you do that? Just say, no, I don't think we have jurisdiction, we don't need to have a hearing, we don't need to reach the issues, it's moot, there's no need to decide it. You can, and there's not maybe a ton of law, but there is law supporting that there's no need to have an evidentiary hearing and go forward with a full-blown hearing. And a board, an administrative board can just have summary disposition. And I think that I had hoped to get something out in writing a couple weeks earlier, and I think we could have done this all on paper. I'm not sure we even needed to have a hearing. Unfortunately, I just wasn't able to get that out in time, where I think I could have made a written request on these same bases to just summarily decline it. I was tempted to advise the department to just not take the appeal at all on this basis. I don't think that was the right thing to do. Arguably doable, doesn't matter. I think that it was the correct thing to do to give Colleen an opportunity to be heard on it, on that first section of whether the board can even go forward, and let the board deny it. So it seemed more transparent, more fair to ask the board to do it. But before we go forward on the actual substance of it, which is the makeup of the board for the December 9th hearing, whether that was done correctly or not, I think just based on the overall fact that it's not without importance that things in general be done according to code, and I understand that, but as far as mootness, just in terms of is there anything that can be done anymore about the December 5th makeup, not really. It doesn't affect, they're not saying it actually impacted the December 9th hearing. It's just an error made in a vacuum that could have been appealed in a timely manner to the full board, but is now just being appealed to issue some advisory opinion that I don't think the board has the ability to do. So that was wordy. I'll stop, and if you have any questions.
Does any of the panel have questions?
Yeah, I guess I have a question. I mean, we've all assembled here today. Do you think there's any harm in just moving forward and kind of seeing the issue through so we can get a better understanding of it and maybe, not have this be an issue in the future? Do you think there's any harm in just going through the process tonight?
Not necessarily in a real harm other than time consumption. I mean, I believe we will prevail on the substantive argument if we have to, if we do go forward. I absolutely believe that we will. So other than the fact that it's time consuming, and the other concern that I have is that I just want the board to look carefully at what it's being asked to do and the procedural posture that it's in, because I'm not sure that we all should be assembled here tonight at all. And so that's my concern and why I want to get it out there. If you choose to hear it, then we'll proceed accordingly.
Mr. Perdine, do you have a question?
None at this time. I'd like to hear the appellant's point on it.
If I might ask a couple following questions. At this point, are there openings on the board that have yet to be appointed? And do they relate to any specific expertise that are not filled?
This time, openings on the board is electrical contractor. And then it's up to 15 members. We have 2 additional kind of general spots, like anyone in the industry.
So right now, the residential are Mr. Michelson, Mr. Hawkinson?
No. At this, when we get to the, if you decide to hear it, we can discuss the composition. But if you'd like, at this present time, it's a little tricky because Mr. Michelson is no longer on the board. His timing was, his term expired in October 14th, which was before the appeal.
Okay.
The appeal that was heard December 9th was submitted November 22nd. So Mr. Michelson was not on the board at that time. Mr. Loken and Mr. Hickle are, Mr. Tyler Loken and Mr. Ray Hickle have been subsequently appointed to the board as residential construction. Well, actually, Mr. Hickle was appointed for the spot representing residential building. Mr. Loken as a general contractor, general member. However, they were not confirmed by the Assembly until November 19th, and the appeal that was heard December 9th was again submitted on November 7th.
Okay.
So they would not have been on the board at the time that appeal was submitted, and have still not been sworn into the board, which will happen next week at the business meeting of the first of the year.
I appreciate your caution. I'm going to throw a band into the wind. So
Okay.
Mr. Hawkinson's still on the board.
Mr. Hudson is.
And once we have our next meeting, 2 other members will be sworn in. And from Mr. Hawkinson, these 2 other members, one could arguably say that they have expertise in
Correct.
residential construction. And this is a question that I don't know the answer, so I'll throw it out. If I were to appeal to a decision, an administrative decision, and you were to go about scheduling a 3-panel hearing, and let's say that you tried to do the best with the makeup, but it didn't work on schedules, can you indefinitely postpone scheduling the meeting, not saying that you would, until you have that right makeup, or do you have a trigger of time that you have to set a panel?
May I suggest that we're kind of getting ahead of the procedure, in that would be us presenting our case on the merits, and the appellant is supposed to put their case first? Or,
Why?
I'm happy to answer if you would like me to.
It's frustrating to come here and stretch evenings out,
Okay.
from my perspective.
Well, I'm happy to answer.
And I just would like to, I guess I'm hearing, maybe I should just put it to the panel. Does the panel care to wade into this water, or are they in the mindset of looking at it as not being heard?
Well, I think we owe it to the appellant to give us a reason why we should hear. We've only heard one reason why we shouldn't even go into it. So with all respect, we should be giving them opportunity to tell us why we should hear it, and then if we decide to hear it, then we can dive into the case at that time.
And you feel that you can come to that edge of the waterfall and back off?
Well, I think so, because I think some of the discussions are going to be more on, once we get into the case, how the 3 panels are set up and what constitutes getting into the actual makeup of the 3 panels. But I think right now, the question is 2310-103.4.1, which is, can we even discuss it?
Well, here's the frustrating part, if I might. I was on this, and so my concern when I was heard that this was coming was, do I have a conflict of interest, and why isn't this going to the full board? And we're getting finite to say we're hearing the appeal because it wasn't, that the committee wasn't formed correctly. So I would almost say that I have a conflict of interest to hear this.
That was one of my questions, is this in fact a separate appeal altogether? And is that why we're here, is because this is technically a whole different appeal, not on the subject matter, but on the process? Because otherwise, if it's about, well, that was the question that came up to begin with, was why, how are we even here? Why is there a second, third panel review? Why is this not going to the full panel? Because
well, it's a whole different thing. So I guess the question then.
And I would, if I may, I would say that we considered that ourselves and came to the conclusion that it is an entirely different matter, especially with the appellant asking that, the appellant's asking in general terms that the board determined that they're appealing the decision of December 5th, which was that the building official and the chair of the board have the latitude to pick a panel. It's clearly stated in A1, 231041A1, that the panel composition is by the chair of the board and the secretary to the board. It gives complete latitudes as may select if other people are not available. So there, the appellant appears to be asking if the appeal appears to be appealing that the language of the code says they may do that, which the language of the code says they may do that. So that's the question, is the decision of the chair of the board and me to
This whole thing is going to go through this process. We could hear it, we could take a vote one way or the other, but the bottom line is it's an interpretation of the ordinance. And I don't think we're the body that interprets the ordinance. I think the makers of the ordinance are the ones that should weigh in on this issue with advice of legal counsel. And I just think that it's going down a path that we're being asked to do something that isn't in our purview.
Yeah, I would agree with that. I mean, basically, I've kind of gone through this material, and basically, we've got attorneys arguing back and forth about legal issues, and we are not legal experts. We're experts in the field of building, so it's not up to us to make that determination. And, all we can do here tonight is grant or deny the appeal, and whether we grant it or deny it, I don't really see that as changing how we do things in the future. So we can spend time going, and I think right now, we as a panel just need to decide whether we hear it or not. And each time someone starts talking about it, they're actually getting into the merits of the case. And we just need to decide whether we're going to hear it or not, and spend a couple hours kind of working through it, I guess.
My thought is, question to the appellant, can you make an argument of, limit your comments to why we should be here and why we should hear it, and what gives us or this, in your opinion, just on the merits of whether we should move forward or not, what gives us on the merits of this and why we should be even here tonight? and then we can. But I think it, with all respect, allow you to have your things on the record as well on why we should even be here, and that'll allow us to also ask you questions. In return, we've just been asking questions of this side of the room, and I think we need to be.
If I might, as the chair, I'm going to weigh in on this, and before we even consider that, I want the chair to, or the panel, to vote as if they're going to hear this appeal or not. I'd like to hear a motion.
Make a motion that we hear the appeal.
Is there a second?
I'll second that for
Any
discussion
discussion?
purposes.
Hearing none, I won't be supporting the motion. I don't feel that there really is influence or purpose for us hearing this, and I think it ultimately resides with this being resolved with makers of ordinances in terms of intent and process, and that what we're being asked to do is just not tell them the situation.
I won't be supporting the motion either, because I don't think it's our expertise to be deciding legal issues, and that's basically what this comes down to.
Any further discussion?
Yes, I've read through the section that discusses the roles and responsibilities of the board, and as well as so underneath the paragraph A here, the appeal panels, in order to hear and decide appeals from decisions of administrative officials and other enforcement orders. This wasn't a decision, it was a process. Read through the other portions of 103.4.1, the statement of paragraph to hear and decide appeals from decisions of administrative officials relating to building and fire regulations under municipal code. This isn't in that category as well. And though I understand the concern and the point, what this is trying to get at, I would have to agree that by the writing here, I could not support that motion just because I don't see within the regulation the latitude it would give this panel to decide on a process as opposed to strict outcomes of previous appeals.
Any further?
I would be against it.
Any further discussion? Hearing none, if we could have a roll call vote. And the motion before us was to hear the appeal. So a yes vote would be to hear it, a no would be to not hear it.
Mr. Feller?
No?
Mr. Ferdine?
No.
Mr. Steele?
No.
Free.
I would just like to post on the record our objection to not being allowed to present our case. That's why we have, at this point, been denied the right to make any argument in front of this commission, this board, for our appeal. And I completely understand and respect your ability to make a decision about your own jurisdiction to hear an appeal, but at this point, my client's been denied the right to even make a case in front of the commission. And so I'd just like to place that on the record in this hearing.
If I might, I'd like to suggest that I would offer up a motion that the building official, through legal department, contact the municipal assembly and suggest that there's an issue with the ordinance as written that maybe deserves some further clarification relative to their intent of the board makeup. In a specific case recently has been appealed with the board didn't hear, suggested that it was an appropriate panel member or structure, yet the substantive issues were the completeness of submittal packet, didn't have anything to do with whether it was a house or a commercial building. It was a permitting process. The committee at the time was all well-versed and experienced, but it's resulted in an issue where the appellant and their representative, the attorney, is suggesting that they're not getting their due in terms of the board. And the bottom line is that this specific issue is, I think, fraught with newness. The ordinance is untested, and that suggests that the Assembly retest some of the language to clarify the intent for further.
And while we're still on record, just to, for the record, as historical, a year ago, when we had the first annual meeting of the board, dictated in code which panels shall be set. It says up to 2310-1034A1, up to 5 hearing panels should be established the first meeting of each calendar year to hear appeals from decisions of administrative officials and other enforcement orders. 4 panels were set at last year's meeting: civil structural panel, architectural panel, plumbing, mechanical, and electrical. At that time, perhaps, again, due to newness, there wasn't a discussion of a residential panel versus a commercial construction panel. There wasn't consideration, do we need an administrative panel to discuss process issues? There is a meeting next week, and those items could be discussed at that time. Or can be determined that, on a question that is not of the specific engineering construction discipline, then any member of the panel shall be deemed qualified to be relevant. Something along that order is what we were thinking as this was unfolding. I would also say that, so at this time, just for history and to be on the record, no residential panel, no administrative panel is established. A1 gives the secretary of the board, the building official, and the board chair complete latitude to assign members to specific panels. And I quote, says, may request members to take the place of regular assigned panel members when an assigned panel member becomes unavailable, or to provide technical familiarity. I described earlier the timing of what was going on with how many members on the board were residential. In fact, the board chair and I did ask Mr. Hawkinson, the residential member sitting at the time, if he could participate. He was unavailable. Mr. Michelson was no longer on the board. He had not been replaced yet, with confirmed members. So, given the remaining members of the board to choose from, Mr. Steele and Mr. Bonner are reasonable substitutes. But again, as previously stated, the December 9th appeal involved the process for submitting an exempt building permit. The only technical familiarity required would have been the ability to read the code and determine administrative requirements in the code had been met. And the disciplines, trades, and professions relevant to that appeal would be those of all presently on the board. So that's the history.
If I just might, and I will let you speak. I'm sorry, Mr. Ferdinand, please.
Well, Mr. Chair, if I may, we have decided on this not to hear any further on this, and I'm uncomfortable with us discussing the case since we've said we're not going to hear it.
We're not discussing the case, I'm not.
Well, but this is describing the merits of
Right.
the appellant, and I think that we should be stopping at this point. As a group, we decided to stand away from this, and I think any more discussion about the merits of either the appellant or the appellee goes beyond what our decision is.
Motion for adjournment?
One more
May I have a
candle.
motion for adjournment, please? Motion to adjourn. Is there a second? Moved and seconded. This time, the board is adjourned. Thank you all.